Good morning, all. Today is the first revisionary session of the company law, which is applicable for CMA Intergroup 1. And the company law covers the 470 sections and 7 schedules. And in today session, I will complete till section 10A, which is the commencement of business. And so let's get start with the institute mat, which is ICMA study mat. Okay, so first we will discuss the definition of the company. So in terms of the Companies Act 2013, a company means a company incorporated under this act or under any previous company law, which is mentioned in section 2 clause 20. Okay, this is a definition of the company as per the Companies Act 2013. Here are the salient features of the company. First, the separate legal entity. Company is a separate legal person, an artificial person. Although it is not a natural person, it is an artificial person. It is distinguished from the shareholders of the company and it has its own independent corporate existence. Of course, it is distinguished from the shareholders of the company. Shareholders are different and directors are different. It has its own independent corporate existence. Second is the limited liability. The liability of the members of the limited company having share capital is limited to the unpaid value of shares held by them. This is the limited liability feature of a company. Next is the perpetual succession. The company has its existence from the time of incorporation to winding up. Members may come and members may go, but the company survives up to the winding up. मतलब हम जब कंपनी का स्टार्ट करते हैं तो हम मानते हैं कि उसका जो सर्वाइवल एग्जिस्टेंस रहेगा वो टिल द वाइंडिंग अप रहेगा. इसमें मेंबर्स आएंगे, मेंबर्स जाएंगे, बट द कंपनी सर्वाइव्स अप टू द वाइंडिंग अप. नेक्स्ट स्टेप इज सेपरेट प्रॉपर्टी. द कंपनी इज हैविंग राइट टू एक्वायर एंड ट्रांसफर प्रॉपर्टी इन इट्स own name. They have the right to acquire and the transfer property in its own name. Next is the common seal. Common seal was mandatory requirement in Companies Act 1956. Although after the commencement of the Companies Act 2013, it becomes optional to have a common seal. So let's get start with the provision of common seal. The common seal is used by the company for affixing it in the documents such as contract, etc. Since it is an artificial person and cannot sign on its own in the documents, now the use of common seal has been made optional, and the Companies Act 2013 required common seal to be affixed on certain documents such as bills of exchange, share certificates, etc. And all such documents which required affixing the common seal may now instead be signed by 2 directors or 1 director and the company secretary of the company. अभी क्या कह रहा है? Company seal is used by the company for affixing it in documents such as contract. Common seal company use करता है for affixing it in documents जो हम contract में affix करने के लिए. ये although एक artificial person है और अपना document sign खुद नहीं कर सकता, इसलिए एक common seal होती है company की. Now the use of common seal has been made optional. ये optional हो गया and the Companies Act 2013 required common seal to be affixed on certain documents जैसे bills of exchange, share certificates and also documents which require affixing the common seal. अब वो उसकी जगह may be signed by the 2 directors or 1 director and the company secretary of the company if exist. Okay. The next feature is the transferability of shares. Transferability of shares. The shares of the members except in the private company may be freely transferable. मतलब there are certain restriction in case of private company, but in case of public company the shares may be freely transferable. Capacity to sue and be sued. Being a separate legal entity, the company is having capacity to sue others and it can be sued by others. The next topic is the lifting of corporate veil, which overrides the separate entity legal entity feature. The separate personality of a company is a statutory privilege, but it must be used for legitimate business purpose only. It should be used for business purpose only. Where the fraudulent and dishonest use is made of the legal entity, the individuals concerned will not be allowed to take shelter behind the corporate personality. Means कि individuals अगर कोई fraud या dishonest यूज़ होगा लीगल एंटिटी के थ्रू, तो इंडिविजुअल्स कंसर्न, जो उसके साथ इंडिविजुअल्स हैं, will not be allowed to take shelter behind the corporate personality. They cannot take shelter behind the corporate personality. The court will break through the corporate shell and apply the doctrine of what is called lifting or piercing the corporate veil, and the court will break through the corporate shell and apply the principle of doctrine, which is called the lifting or of the corporate veil, which look behind the corporate entity and take action as though no entity separate from members existed. अब देखिए इसमें although I have studied that कि both are separate, but इसमें लिख दिया and take action as though no entity separate from the members existed and make the members of the controlling persons liable for debt and obligation of the company. ठीक है, although company has its corporate existence, but if it is used for the fraudulent and dishonest purpose, the real persons behind it cannot take the shelter behind the corporate personality, and the court will look behind the real persons who are in that fraudulent and dishonest areas. Okay, so in the following circumstances, different courts found it necessary to lift the corporate veil and punish the actual persons who did wrong or unlawful acts under the name of the company. And here it is the following areas or the circumstances where the different courts found it necessary to lift the corporate veil and punish the actual persons who did wrong or unlawful acts under the name of the company. First is the protection of revenue. The court may ignore the separate legal entity status of the company. As I already told that here in this doctrine, the court may ignore the separate legal entity status of the company if it is used for tax evasion or circumventing tax obligation. Okay, next is the determination of the enemy character of the company. Company being an artificial person cannot be enemy or friend, but during war it may become necessary to lift the corporate veil and see the persons behind it to determine whether they are friends or enemy. So this is due to the reason that though a company enjoys the separate legal entity status, but its affairs are run by the individuals. Okay, next is the prevention of fraud. Where the company is used for committing frauds or any improper conduct, the court will lift the corporate veil and look at the realities of the situation. Next is the protection of public policy. The court shall lift the corporate veil without any hesitation to protect the public policy and prevent transaction opposed to public policy. ठीक है, the court shall lift the corporate veil without any hesitation to protect the public policy, for the protection of public policy. And next is the company mere sham or cloth. Where the company is a mere sham and a ploy used for committing illegalities, the court shall lift the corporate veil. Next is the where the company acts as an agent of its shareholders. Where the company acts as an agent of its shareholders, the court shall lift the corporate veil. Avoidance of welfare legislation. Where the company tries to avoid its legal obligations, the corporate veil shall be lifted to look the real picture. Next is to punish for contempt of court. If the company being an artificial person cannot disobey the orders of the court, the persons at fault should be identified, and this doctrine will come in picture. Okay, with this your first area of section, that is section 1, is over. Now we will start with the next section, that is section 2. Although it is talk about definitions, but for this part, although there are many definitions, but so it's not possible to discuss each and every definition in the revision session, but I will discuss the types of companies which are classified on the various bases. So let's get start with that. First is from 289 here. Types of companies. Companies are of various types. The companies are classified under various categories. First, on the basis of liability. The companies are classified according to their liability into the following. First, the limited by shares. Second is the limited by guarantees. Last is the unlimited companies. What do you mean by company limited by shares? Company limited by shares as a company having the liability of its members limited by the memorandum, if any, unpaid on the shares respectively held by them. What is on the unpaid on the shares respectively held by them. Next is the company limited by guarantee. Company limited by guarantee, as a company having the liability of its members, is limited to such memorandum amount as the members may respectively undertake to contribute to the assets of the company in the event of its being wound up. It is the company have the liability of its members limited by the memorandum to such amount. ठीक है, तो that amount their liability will be restricted. Next is the unlimited company. What do you mean by unlimited company? Of course, a company which not having any limit on the liability of its members. Next classification, it is on the basis of the number of members. The companies are classified on the basis of number of members as follows. What is public company and private company? So public company is defined under section 2 clause 71, which defines the public company as a company which is not a private company. So in order to understand what is a public company, we have to read the definition of the private company, which is defined in section 2 clause 68, which defines private company as a company having minimum paid up capital as may prescribed, and company which is by its articles. There are 3 points here which restricts the right to transfer its shares, although we have discussed in case of features of company also, where the private company was an exception, that there's some restrictions to right to transfer its shares if there is a public company. So next is the except in case of 1% company, limits the number of its members to 200, limits the number of its members to 200. Okay, prohibits any invitation to the public to subscribe for any securities of the public. The private company cannot go to the public to subscribe for their securities, then so they cannot go, it prohibits. So there are 3 areas in case of the private company. They restricts the right to transfer its shares, they limits the number of its members to 200, and prohibits any invitation to the public for subscription of the securities of the company. Okay, and the following person shall not be included in the number of members, which is limits to 200, which is the persons who are in employment of the company and the persons who have been formally in the employment of the company, were members of the company while in that employment and have continued to be members of the employment cease. Who have been formally in the employment of company and who are in the employment of the company are not included in the number of members. The next area is the on the basis of control. The companies are classified on the basis of control as follows. First is the holding company, next is the subsidiary company. So what do you mean by holding company? As per section 2 clause 46, the holding company in relation to one or more other companies means a body corporate of which such companies are subsidiary companies. So let's get read once more. In relation to one or more other companies means a body corporate of which such companies are subsidiaries. So for more depth in case of holding companies, we need to read the subsidiary companies definition. Section 2 clause 87 defines subsidiary company in relation to any other body corporate as a company in which the holding company controls the composition of board of directors or controls more than one half of the total voting power. So it gets related with the holding company. So in order to understand the holding company, we need to know what is the subsidiary company. It consists of 2 features, means it controls the composition of board of directors or controls more than one half of the total voting power. Next is the on the basis of listing of shares. The public limited companies are eligible for listed its shares on the stock exchanges, and on this basis the public limited companies are classified as listed company and unlisted company. What do you mean by listed company? It is a company which has any of its securities listed on a recognized stock exchange. Unlisted company, a company which is not listed its shares on any stock exchange, is called non-listed company. Next is on the basis of government control. The companies are classified on the basis of the control of the government over the company as government company and non-government company. So what do you mean by government company? Section 2 clause 45 defines the government company as any company in which not less than 51% of the paid up share capital, not less than 51% of the paid up share capital is held by the central government or by any state government or governments, or partly by central government and partly by one or more state governments, and includes a company which is a subsidiary company of such a government company. ठीक है, तो इसमें कितना होल्डिंग चाहिए? 51% of the paid up share capital is held by the state government or by state government, either partly by both central government or state government. And what is non-government company? A company in which either of the company has no paid up share capital is called a non-government company. इसमें गवर्नमेंट का कोई नो पेड अप शेयर कैपिटल, गवर्नमेंट का कोई शेयर कैपिटल नहीं है उसमें, उसमें इज इन विच आइदर ऑफ द स्टेट गवर्नमेंट हैज़ नो पेड अप शेयर कैपिटल इज कॉल्ड द नॉन गवर्नमेंट कंपनी. Next, the classification is on the basis of other types of companies. The other type of companies are as follows: the associate company, banking company, foreign company, one-person company, small company, Section 8 company, dormant company, inactive company, producer company, investment company, and the statutory company. So, what do you mean by the associate company, which is defined in 2 clause 6, which defines the term associate company in relation to another company, a company in which that other company has significant influence. What do you mean by significant influence? It means the control of at least 20% of the total share capital or the business decisions under an agreement. Next is the banking company, which is defined in section 2 clause 9, which defines the banking company as a banking company defines in section 5 clause C of the Banking Regulation Act 1949. Next is the foreign company. So what do you mean by foreign company, which is defined in section 2 clause 42, which defines a foreign company as any company or body corporate incorporated outside India, which is incorporated outside India, which has a place of business in India, whether by itself or through an agent, physically or through electronic mode. देखिए इसमें तीन चीज़ें हैं. A company which is incorporated outside India, जिसका place of business India में है, either by itself or through agent, physically or in electronic mode, and conducts any business activity in India in any other manner. This is called the definition of the foreign company. Next is one-person company. Although one-person company is defined in section 2 clause 62, which defines a one-person company as a company which has only one person as a member and is also called as a private company. Only one person as a member and is also considered as a प्राइवेट कंपनी. अभी मैंने इसमें डिटेल में जाऊंगी, अभी धीरे धीरे इसमें डिटेल में जाऊंगी व्हाट यू मीन बाय वन पर्सन कंपनी. ठीक है. ठीक है. नेक्स्ट इज the small company. Section 2 clause 85 defines small company as a company other than a public company. Paid up share capital of which is not exceeds 50 lakhs or such an amount as may be prescribed, which shall not be more than 10 crore. Means paid up share capital which doesn't exceed 50 lakhs and the turnover of which is as per its P&L for the immediately preceding financial year doesn't exceed 2 crore or such higher amount. ठीक है. Although it got amended by the Companies Amendment Act 2020, but it is for your this attempt the Companies Act Amendment Act 2019 is applicable. So this is the limit which you have to learn in case of small company. Although it gets amended when the Companies Amendment Act 2020 will applicable. Okay. This definition shall not apply to a holding company or a subsidiary company. होल्डिंग कंपनी और सब्सिडरी कंपनी पे ये डेफिनेशन अप्लाई नहीं होगी. सेक्शन 8 कंपनी और अ कंपनी और अ बॉडी कॉर्पोरेट गवर्न बाय एनी स्पेशल एक्ट. गवर्न बाय स्पेशल एक्ट. बैंकिंग कंपनी, इंश्योरेंस कंपनी, ऑल्दो यू हैव ऑल्सो स्टडीड इन योर कंपनी अकाउंट सिलेबस विच इज इन CMA इंटरग्रुप 2. सो ओके. नेक्स्ट वी विल कम टू सेक्शन 8 कंपनी. ठीक है. अब देखिए इसमें कुछ चीज़ें इसमें डेफिनेशंस हैं और ब्रॉड प्रोस्पेक्टिव्स भी हैं, तो मैं ब्रॉड प्रोस्पेक्टिव्स भी लूँगी अभी. ठीक है. सेक्शन 8 कंपनी का हम पहले एक डेफिनेशन पढ़ लेते हैं, फिर डिटेल में पढ़ेंगे. सेक्शन 8 कंपनी. सच टाइप ऑफ कंपनी इज टू बी रजिस्टर्ड विद द रजिस्टर ऑफ कंपनीज एंड ऑल्सो टू obtain लाइसेंस फ्रॉम द सेंट्रल गवर्नमेंट if the person or association of person proposed to be registered under the Companies Act 2013 as a limited company has its objects the promotion of commerce. Their object should be the promotion of commerce, arts, science, sports, education, research, social welfare, religion, charity, protection of environment, or any such other object. And they should intend to apply its profit, if any, in promoting its objective. Okay. and it intends to prohibit the payment of any dividend to its members. So there are 3 points in the section 8 company. First, their objective is the promotion of commerce, arts, science, sports, education, research, social welfare, charity, and etc., and it intends to imply its profits in order to promoting its objectives, and it intends to prohibit the payment of any dividend to its members. ठीक है, तो ये हो गई आपकी सेक्शन 8 कंपनी. नेक्स्ट इज डोरमेंट कंपनी विच इज डिफाइंड इन सेक्शन 455 ऑफ द एक्ट provides that where the company is formed and registered under the act for the future project, where the company is formed and registered under the act for a future project or to hold an asset or intellectual property and has no significant accounting transaction, where the company is formed and registered under act for a future project or hold an asset or intellectual property and has no significant accounting transaction. Such a company or an inactive company may make an application to registrar for obtaining the status of the dormant company. Okay, next is the inactive company. So explanation 1 to section 455 defines inactive company as a company which has not been carrying on any business or operation or has not made any significant accounting transaction, which has not been carrying on any business and which has not made any significant accounting transaction during the last 2 financial years and has not filed financial statements and annual returns during the last 2 financial years itself. ठीक है. Next is your producer company. According to the provisions as prescribed in section 581A of the Companies Act 1956, the producer company is a body corporate having objects or activities specified in 581B and which is registered as under the provisions of the act. The membership of the producer company is open to such people who themselves are the primary producers. The membership of producer companies is open to such people who are the primary producers, which is an activity by which some agriculture is produced by such primary producers. Okay. Next is the investment company. Explanation 8 to section 188 defines the term investment company as a company whose principal business is the acquisition of shares, debentures or other securities. Their business should be the acquisition of shares, debentures or other securities. Okay. Next is the statutory company. Companies set up by the special act of parliament or state legislatures are called the statutory companies. For example, the RBI setup is under the RBI Act. Likewise, LIC, UTI, etc. are the examples of the statutory company. Here are some other questions on which you have to answer. ठीक है. अब मैंने दो, आपको 1 मिनट रुकिएगा. ठीक है. मैं एक बार 1% कंपनी एंड स्मॉल कंपनी को थोड़ा 1% कंपनी को मैं थोड़ा डिटेल में लेके जाऊंगी, क्योंकि ऑल द ये आपके ऑफन अकरिंग आया हुआ पेपर में, इसमें थोड़ा सा और डिटेल बताऊंगी. पहले तो हमने डेफिनेशन पढ़ा था अंडर सेक्शन 2 क्लॉज 62 ऑफ द एक्ट विच इज़ ओनली 1% एज अ मेंबर, एंड सेक्शन 3 ऑफ द एक्ट इंडिकेट्स द OPC इज अ प्राइवेट लिमिटेड कंपनी. ओके. एज पर रूल्स व्हाट इज द एलिजिबिलिटी फॉर इट? And Rule 3 of Companies Incorporation Rules 2014 provides that only a natural person, there are three, first the person should be natural person who is an Indian citizen, and third is the residency, shall be eligible to incorporate an OPC and shall be nominee for the sole member of an OPC. So what do you mean by resident in India? As you've already studied in the taxation, direct taxation itself, which is in group CMA group 1, the chapter name is residential status, where we already studied that who has stayed in India for a period of not less than 182 days during the immediately preceding 1 year will be considered as resident in India. Next, here the conditions in the formation of OPC. Here the following are the conditions in formation of OPC. No natural person shall be eligible to incorporate more than a OPC or become a nominee in more than OPC. कोई भी natural person shall eligible to incorporate more than a OPC, एक OPC से ज़्यादा, and to become nominee in more than a OPC. ठीक है. ये हमने पढ़ लिया. Where the natural person being a member of OPC in accordance with this rule becomes a member in another such company by virtue of this being a nominee in that OPC, सच पर्सन शैल मीट द एलिजिबल क्राइटेरिया, उसे 182 डेज वाला क्राइटेरिया फुलफिल करना है. नो माइनर शैल बिकम द मेंबर और नॉमिनी ऑफ ओपीसी, कोई भी माइनर मेंबर नहीं बन सकता, नॉमिनी बन सकता, और कोई भी शेयर विद बेनिफिशियल इंटरेस्ट होल्ड नहीं कर सकता. नेक्स्ट है द company cannot be incorporated or converted into section 8 company. It should not be converted, cannot be converted or incorporated into section 8 company. Such a company cannot carry out non-banking financial investment activities, including activities in securities of any body corporate. They cannot carry out any non-banking financial investment activities. No such company can convert voluntarily into any kind of company unless the 2 years have expired from the date of incorporation of OBC, except where the threshold limit of paid up share capital is increased beyond 50 lakh and average turnover increased exceeds 2 crore, as I have already studied in case of small company definition. ठीक है. So what do you think, what is the benefit of 1% company? What do you mean by by the benefits of the 1% company? It gives the individual entrepreneurs all the benefits of the company's features, which means they will get credit, they will get the bank loans and access to the market. They will get the limited liability, and legal protection is available to company. Means all the features will get applied to them, and they can do their work peacefully under the legal protection which is available to them in the form of a body corporate. Okay, so prior to the New Companies Act 2013 coming to effect, at least 2 shareholders were required to form a company. Means for starting a private company need for there are no 2 shareholders which are required to start a company, क्योंकि कंपनीज एक्ट 1956 में ये फीचर नहीं था. बट फ्रॉम द विद द इफेक्ट फ्रॉम कंपनीज एक्ट 2013, but now the concept of 1% company which got arrived and which state that which would provide tremendous opportunities for small companies and traders, including those working in areas like handloom and handicrafts. Earlier they were working as artisans and weavers on their own, but they do not have any legal identity. But now the OBC would help them to do business as an enterprise and to giving them an opportunity to start their own ventures with a formal business structure. Okay. And the third is advantage, the benefit of having a 1% company to such entrepreneurs, to such individual entrepreneurs, is that the lesser compliance as compared to the other private, as compared to the public and private company. There's a lesser compliance in case of 1% company in filing of returns, balance sheets, audit, etc. Although rather than middleman usurping profits, that 1% company will have direct access to the market and the wholesale retailers. And new concept would also boost the confidence of the small entrepreneurs, and they will get the environment of the formal business structure. Okay. Although it is not possible for me to read out every section in detail, but I will try to cover all the concepts related to it. Okay. ठीक है. Nominee can also be appointed in that. It is not possible for me to go in detail in that, so you get wanna read to it. Okay, जो मेन पॉइंट्स है, मेन क्रक्स है, मैंने आपको समझा दी. व्हाट इज़ द 1% कंपनी एंड व्हाट इज़ द एलिजिबल क्राइटेरिया एंड अदर्स ऑल्सो. सो इसमें मैं आपको एक एनुअल रिटर्न का एक बार ज़रूर बोलूँगी. एनुअल रिटर्न ऑफ एन ओपीसी शैल बी साइन बाय द कंपनी सेक्रेटरी. कोई भी जो एनुअल रिटर्न है ओपीसी की शैल बी साइन बाय द कंपनी सेक्रेटरी, और वेयर देयर इज नो कंपनी सेक्रेटरी बाय द डायरेक्टर ऑफ द कंपनी. ओके. So this covers with the 1% company. Just go through the section. It's not possible for me to cover all the points in the revisionary session of it. So I will try to cover the maximum points that can I cover in this short video. Okay. So you have to look at the book itself and then go through the video. It would be easy for you to to recall the concepts easily. Okay. So next section is section 3 of formation of company. Next is the section 3, the formation of the company. Section 3 talks about the formation of the company, which provides this section provides the company may be formed for any lawful purpose. The company cannot be formed for illegal purpose or for unlawful purpose. And this is also further provide that the number of members required to the formation of a company. ठीक है, पब्लिक कंपनी में आपको कितने चाहिए होते हैं, 7 और मोर पर्सन्स चाहिए होते हैं. मिनिमम आपको चाहिए, मिनिमम जब देखिए मिनिमम ऑफ द public minimum for the public company is 7, and there is no limit for the highest number of members in case of public company. Although the private company can be start from 2 or more persons, and the minimum for the private company is 2, and maximum number can be limited to 200, as already studied in case of definition of private company, which restricts the maximum number of members, which is 200. One person company requires one person, as already studied in case of one person company, features in detailed itself, and is also treated as a private company. ठीक है, तो दिस कवर्स विद द section 3, and section 3 subsection 2 also provides that the companies are formed may be either the company limited by shares or the limited by guarantee or an unlimited company. So this covers with the section 3, which is the formation of company. Although it is not possible for me, I think, to cover the whole section 10 in this video itself, so I will cover maximum in this video, and if something is left I will continue in the next video. Okay, the next is the section 4, which is the memorandum of association. So what do you mean by memorandum of association? Although the memorandum of association is the charter of the company, it is the charter of the company, and articles of associations, which is the section 5 itself, mention the rules. Wait, memorandum of associations. Here it is a memorandum of association. So what do you mean by the memorandum of association? As I've already said, it is the charter of the company and the scope of the powers of the company, which has been established under this act. It is a very foundation on which whole edifice of the company is built. As per the section 4, the memorandum of limited company must state the following. So there are following clauses in there. It's not possible for me to go through deep, so I will restrict my words in limited form. First, the clause is the name clause. Second is the situation clause, object clause, liability clause, and the capital clause. In all these clauses should be mentioned in your memorandum. First, so what do you mention in the name clause? The name of the company with limited as its last word in the case of public limited company, and the private private limited as its last word in the case of private limited company. But this provision is not applicable in case of section 8 company, which is the section 8 of the Companies Act. Similarly, in case of government companies, the name of the company shall end with the words limited. This is as per the exemptions to government companies under section 462 of Companies Act, by notification dated 5 June 2013. In case of government company, the name of the company shall end with the words limited. And this is as per the exemptions. The exemption to government companies under section 462 of Companies Act 2013, by notification dated June 5, 2013. Next is the situation clause. What do you mean by situation? Means location. So what do you mention in the memorandum about the address and all? You just only give the state in which the registered office of the company is to be situated, either in Delhi, either in some other state, whatever it is. Next is object clause. The object of the company means for what purpose the company is incorporated, which need to be disclosed in your memorandum. The objects for which the company is proposed to be incorporated and any other considered necessary in furtherance thereof. Okay. Next is the liability clause. The liability of the members of the company, whether it's limited or unlimited, must also state that in case of company limited by shares, or there are two categorization. In case of company limited by shares, the liability of its members is limited to the extent the unpaid shares held by them. As already discussed in the definition when we have studied the classification of the types of companies, in which one of the categorization is the company limited by shares and company limited by guarantee. ठीक है. In case of the company limited by guarantee, the amount up to which each member undertakes to contribute to the assets of the company in the event of its being wound up while he is a member, or within 1 year after he ceases to be the member, for payment of debts and liabilities of the company, or such debts and liabilities as may have been contracted before ceases to be a member, as the case may be, and to the cost, charges and expenses of winding up, and for adjustment of rights of the contributaries among themselves. ठीक है. This is the liability clause which covers the company limited by shares and company limited by guarantee. You can relate it with the definitions of it, as I've already discussed in case of द टाइप्स ऑफ कंपनीज. उसमें जैसे आपकी जो आपकी उसके फीचर्स हैं, कंपनी लिमिटेड बाय शेयर्स का जो डेफिनेशंस है उसमें जो कहा गया है कि उनकी अनपेड शेयर्स का लायबिलिटी लिमिटेड रहेगी एंड गारंटी की टू द रिस्ट्रिक्ट टू द अमाउंट टू द मेमोरेंडम अमाउंट and to the assets of the company in the event of its being wound up, तक restricted रहेगी, and the cost, charges and expenses of winding up, and for adjustment of the rights of the contributors among themselves. Next is in case of a company having a share capital, which is the capital clause, the amount of share capital with which the company is to be registered and the division thereof into a shares of fixed amount. अब capital clause is just a company having share capital, ठीक है. तो उनके दैट केस द अमाउंट ऑफ शेयर कैपिटल विद विच द कंपनी इज टू बी रजिस्टर्ड, क्या शेयर कैपिटल क्या है कंपनी का, एंड उसका डिवीजन देयर ऑफ इनटू शेयर्स ऑफ फिक्स्ड अमाउंट, क्या उसका डिवीजन है. आप ऑथराइज शेयर कैपिटल लिखते हैं, इशू शेयर कैपिटल लिखते हैं, उसका क्या डिवीजन है, कितना शेयर कैपिटल से कंपनी रजिस्टर्ड हो रही है, उसका डिवीजन इनटू शेयर्स ऑफ फिक्स्ड अमाउंट कितने शेयर्स के लिए है, एंड द नंबर ऑफ शेयर्स विच द सब्सक्राइबर्स टू द मेमोरेंडम एग्री टू सब्सक्राइब, एंड उसमें से कितने शेयर्स विच द सब्सक्राइबर्स टू द मेमोरेंडम सब्सक्राइब करने के लिए रेडी हुए हैं, जो विच शेल नॉट बी लेस देन 1 शेयर पर सब्सक्राइबर, एंड द नंबर ऑफ शेयर्स ईच सब्सक्राइबर टू द मेमोरेंडम इंटेंड्स टू टेक इंडिकेटेड अपोजिट हिज नेम. जितने भी सब्सक्राइबर्स हैं उनके अपोजिट में उनका नाम के आगे ये लिखना है कि कितने शेयर्स उन्होंने सब्सक्राइब किए हैं, ठीक है. इन केस ऑफ 1 पर्सन कंपनी, द नेम ऑफ पर्सन हु इन द इवेंट ऑफ डेथ ऑफ द सब्सक्राइबर शेल बिकम द मेंबर ऑफ द कंपनी. अब इसमें हमें नॉमिनी का पॉइंट किया था, जिसमें अगर पर्सन इन द इवेंट ऑफ डेथ ऑफ द सब्सक्राइबर द नॉमिनी विल बिकम द मेंबर ऑफ द कंपनी, ठीक है. दिस कवर्स विद द सेक्शन 4 विच इज़ द मेमोरेंडम ऑफ एसोसिएशन. द फॉलोइंग आर द क्लॉजेस which you have to mention in your memorandum. What is the name clause, situation clause. Name clause describe about the name, what to be written after the company's name, either it is limited or private limited. A situation is where there is the location of the registered office of the company, objects for which the company is proposed to be incorporated, and third the liability clause, which is the company which is divided into 2 subparts in case of company limited by shares and in case of limited by guarantee. Next is your capital clause. You have to mention the share capital and its divisions amount and the number of shares which the subscribers to the memorandum agree to subscribe, and against each subscribers you need to number of shares held by the each subscriber अपोजिस देयर नेम, मतलब हर किसी के नाम के आगे कितने शेयर्स हेल्ड करें उन्होंने, ये आपको लिखेंगे, ठीक है. और 1% कंपनी में द नेम ऑफ द कंपनी हु इन द इवेंट ऑफ डेथ ऑफ द सब्सक्राइबर जो है वो शेल बिकम द मेंबर ऑफ द कंपनी. ऑल आई हैव एक्सप्लेन इन डिटेल itself ना. Okay, so this covers with the section 4. Today itself I will able to cover till section 5, and rest I will start rest I will take in next session. Okay, today we will complete with the section 5. which is the articles of association. ठीक है. I thought I am able to recall all the section till section 10, but I think there are more long sections, and so it's not possible for me to go just ऊपर से. एंड आई वांट कि लॉ को आप जितना डीप जाके पढ़ेंगे इट्स गुड फॉर अंडरस्टैंडिंग, एंड आपको ऑफकोर्स लिखना है पेपर में. सो ऊपर का मैं नहीं करा सकती, तो इसलिए हो सकता है इसमें थोड़ा सा टाइम लगे. तो इसलिए मैं सेक्शन 10 तक सोच कर आई थी, बट आई थिंक सेक्शन 5 तक मैं कंप्लीट कर पाऊँगी, क्योंकि थोड़ा आई थिंक डिटेल्ड होना भी बहुत ज़रूरी है लॉ को समझने के लिए. ठीक है, तो नेक्स्ट सेक्शन है आपका सेक्शन 5, विच इज़ द आर्टिकल्स ऑफ एसोसिएशन. ठीक है, वेट 298. Here it is, articles. The section 5 of the act deals with the articles of the company, and the articles of the company shall contain the regulations for the management of the company. It contains the rules and regulations for the management of the company, and table 5 in schedule 1 provides the matters that should be contained in the articles of the company. Okay, ये सेम चीज़ आपकी मेमोरेंडम में भी है. देखिए, मेमोरेंडम में भी आपके फॉर्म्स ऑफ टेबल्स होते हैं, विच इज़ मेंशन इन 4 clause 6. टेबल A, B, C, D and E. A, which is talks about the memorandum of association of a company limited by shares. ठीक है, and table B is for memorandum of association of company limited by guarantee and not having share capital. Next is the company limited by guarantee and having share capital, table C. Table D is for memorandum of association of an unlimited company and not having share capital. And table E is for the memorandum of association of an unlimited company and having share capital. All that is not important, although if for theory purpose, but it can be asked in case of objective purpose also. MCQ's purpose, they can easily be asked which table is for whom. They will give you table A stands for which area. So आपको अलग अलग ऑप्शन दे देंगे, लिमिटेड बाय शेयर्स, लिमिटेड बाय गारंटी, एंड यू हैव टू सेलेक्ट वन फ्रॉम इट. सो इट इज़ इम्पोर्टेंट फॉर द MCQ perspective. नेक्स्ट या टेबल अपनी टेबल F, आप ये ध्यान रखिएगा, टेबल F इज़ फॉर आर्टिकल्स, एंड टेबल फॉलोइंग विद द टेबल्स आर क्लासिफाइड A, B, C, D and E is for and schedule 1 in case of forms of memorandum. ठीक है, इन टेबल में फॉर्म्स दे रखे हैं, हिसाब से आपको प्रिंट किया होता है मेमोरेंडम में. टेबल A to E is for memorandum, and from table F in schedule 1 provides the matters they shall be contained articles of the company limited by shares. ठीक है, तो ये आपके कुछ पॉइंट्स हैं, इंटरप्रिटेशंस हैं. शेयर कैपिटल एंड वेरिएशन ऑफ राइट्स. शेयर कैपिटल कोई वेरिएशन ऑफ हुआ है राइट्स में, लीन शेयर्स पे कॉल, ट्रांसफ़र शेयर्स, ट्रांसमिशन, कोई फॉरफीचर हुआ है, कोई कैपिटल में ऑल्टरेशन हुआ है, बायबैक हुआ है, जर्नल मीटिंग है, आपकी कोई प्रोसीडिंग्स है जर्नल मीटिंग्स की, एडजॉर्नमेंट ऑफ मीटिंग है, वोटिंग राइट्स हैं, प्रॉक्सी है, बोर्ड ऑफ डायरेक्टर्स है, बोर्ड की प्रोसीडिंग्स है, आपके CEO, कंपनी सेक्रेटरी, चीफ फाइनेंशियल ऑफिसर हैं, सी लेयर पर ऑप्शनल हो गई है. अब डिविडेंड्स एंड रिजर्व है, बाइंडिंग अप इंडेमनिटी. फॉलोइंग आर द फीचर्स, फॉलोइंग आर द मैटर्स दैट शैल बी कंटेन इन आर्टिकल्स ऑफ द कंपनी लिमिटेड बाय शेयर्स. ठीक है, टेबल G, टेबल फ्रॉम F, G, H, I, J is talks about the matters related to articles. Table G is the articles of the association of company limited by guarantee and having share capital. Table H is the articles of association of company limited by guarantee and not having share capital. Table I is for articles of association of unlimited company having share capital. Table J is the articles of association of unlimited company and not having share capital. Okay. So this covers with the your memorandum memorandum of association and articles of association. ठीक है. So in this video I have covered the 5 sections. First is the preliminary section, which talks about the definition of companies and its silent features. Section 2, in which we have discussed the types of companies. on various bases. Third is the how the company is formed, private company, public company, one person company. Okay. Section 4 talks about the memorandum of association, which is the charter of the company, and which is in which you have to describe the clauses that like name clause, situation clause, object clause, and the discussion or detailed discussion of the same I have already discussed. Next section 5 talks about the articles of association. ठीक है, इसमें भी हमने बहुत सारा डिटेल में डिस्कशन कर लिया है. सो नेक्स्ट एरिया में मैं आई थिंक एज पर द लेंथ आई कैन नॉट से दैट आई विल कवर द 10 sections per day, but I probably try to cover it. If it is, I think the next sections, some sections are easy and short. It depends on the length of the sections. It not about that I need to cover 10 sections or 15 sections per day, but it's all about the length of the sections. अगर लेंथ आपका बड़ा होगा तो ऑफकोर्स नंबर ऑफ सेक्शंस कवरिंग आपकी कम हो जाएगी. तो ठीक है, मैं डिटेल पढ़ाने की कोशिश करूँगी जितना रिवीजन में और अच्छा रहेगा. ठीक है, आपको और रिकॉल करने में आसान रहेगा. तो नेक्स्ट देखते हैं मैं कितने सेक्शंस करा पाती हूँ. कुछ सेक्शंस इसमें ईजी भी हैं. इफेक्ट ऑफ रजिस्ट्रेशन, इफेक्ट ऑफ MOA, AOA, act to override MOA and AOA, the small sections. Commencement of business, small sections. So in next video I may be able to cover more sections. Okay, so for this session that's it, and thank you.